Welcome to this presentation on the Law Professor channel. Today's video will be looking at the types of maintenance under the Matrimonial Causes Act and other principles under that act that govern maintenance. Maintenance is what we call a financial order that the court gives at the time that the marriage has disintegrated. We are focusing on that aspect of maintenance. The concept of maintenance, of course, could arise while a marriage is subsisting in terms of the duty to maintain each other. But for this purpose, we are looking at it in the context of a marriage that has disintegrated. The parties may be before the court because they want an order of divorce or annulment of the marriage. So in other jurisdictions, this is what is called spousal support or child support. Under the Matrimonial Causes Act, it is lumped together as maintenance for the benefit of a spouse or children of the marriage. So this discussion that we are having today relates exclusively to the Matrimonial Causes Act and therefore governs only statutory marriages in Nigeria. Only statutory marriages in Nigeria. Now, our learning outcomes for today are threefold: to know the types of maintenance, to know the forms that in which they may be issued, and to understand other principles that are attached to the concept of maintenance under the Matrimonial Causes Act of Nigeria. Because maintenance order is an interlocutory order. Even after it has been given, other applications can be made with respect to it. The law of maintenance, therefore, it's a law that it continues to evolve. It continues to evolve. Each jurisdiction determines what modalities to employ in terms of granting maintenance. But there are some things that you see as we go on that are common to most countries, and these commonalities reflect the society in which we live and the structural and cultural dimensions of family law. The Matrimonial Causes Act, as we have always emphasized, actually governs the marriages that are celebrated by virtue of the Marriage Act, the marriages that we call statutory marriages, or that are English based, so to say. And then you look at the part 4 of that Matrimonial Causes Act of Nigeria, which deals with ancillary reliefs. You would see that it is possible under Section 70 to apply for maintenance either in its permanent form or in its temporary form. By permanent, we mean that it is given after the matrimonial dispute, matrimonial cause has been settled. It is given as a permanent order. But that permanency does not mean it is invariable, that it cannot be varied. They might be given as a temporary order. Perhaps you have a marriage that you have applied to the court for dissolution of the marriage. The case has been set for hearing in the next 3 months, and the wife has been sent out of the home with the children. You do not have to wait till the case is heard and completed before you can apply for maintenance order. So an order can be given pending the disposal of the main relief. That's what we mean by temporary, interim order of maintenance. And by the time they now try the case, the court might decide either to discharge the order or to give a permanent order that encapsulates the real interest between the parties. So the permanent maintenance at the completion of the course, Section 70, subsection 1, and this may be granted irrespective of the grant of the order of the matrimonial cause that is before the court. And also expect that you read Section 75 of the MCA for further provisions on that. Then maintenance pendility that I explained earlier, pending the completion of proceedings for the principal relief, you do not expose the vulnerable party to suffering because the case is still in court. So that application may be made, but it will end at the time that the matrimonial course, whether it's a divorce proceedings or judicial separation order, at the time that it is given, the temporary order would be, would end, and a more permanent order may be given, as we have earlier explained. This maintenance award, it's like I said, maintenance means money. The money that the court orders one party to pay for the benefit of the other spouse, where there is a need for it. Okay? So this financial order, this money, it could come as a lump sum order. Section 73(1) MCA. It could be single sum of money in lieu of several. That is just one single sum, just pay something. Felt might say, okay, pay 5 million and that is it. And there's no other obligation to pay any other money to the spouse after that. So a lump sum is a single sum of money in lieu of several. And it is made for all, it's in lieu of all payments that is needed to be made between the parties in a marriage. After that is paid, there's no other financial engagement between the divorcing spouse. Each party can go away forever, as far as that is concerned. What it does is that it removes the need to be interacting between the parties. They can go their way and live their life separately. No bitterness. Sometimes some of the divorce proceedings are quite um it could be very embarrassing, it could be very bitter, very cause a lot of acrimony. And then you find out yourself that you have to be seeing this person or be interacting with this person. Even if you don't see physically, the fact that you have to be transferring money or making payment to that person means the person is continuously your consciousness. So when you have a lump sum, it removes all that. You just pay once and for all, and that is the end of it. There might be a periodic sum of money. The court might say you should pay under section 31A, that you should pay weekly or monthly or yearly or any other periodic sum, depending on the circumstances of the case. Maybe every 6 months, every 8 months, that could be worked out in practice. So instead of the lump sum, this may also be possible. The arguments about the advantage, whether a lump sum is better or not better, are not for this presentation, because there are issues about, oh, okay, when you do a lump sum, there is tendency to waste the money or whatever. That is not before us today. The court may also order that the periodic sum be secured such that it will not be, but it will not say, okay, after you paid 6 months, say there's no other money or whatever. So there could be some or securities that could be given to ensure that that money continues to come to be paid. It may be paid directly to the party to the marriage, to the spouse. It might be paid to a trustee. If it's a maintenance or they're giving for the benefit of the spouse, it might be given to that spouse. If it's given for the benefit of children of the marriage, for instance, the court might order that it be paid to a trustee that is appointed to an officer of the court or a public authority for the benefit of um the children of the marriage. So the maintenance under the Matrimonial Causes Act would be given for the benefit of a spouse or and children of the marriage. And so it's possible to appoint a trustee for the benefit of the beneficiary to ensure that the money does not get is not dissipated on um, unnecessary considerations and uses. The duration of the maintenance order. If you look at section 73(1)(h) of the Matrimonial Causes Act, we've said that it could be lump sum or periodic. So if it is a lump sum, of course, you pay it once and for all, and that is the end. It could be periodic, which may be permanent, like just continue to pay it. Or it might be, like we said before, it may be order that is pending disposal of proceedings. It could be for a fixed sum. It might see that you should pay the periodic sum for the next 5 years, after which maybe it's for the child, for instance, by that time of which the child could have finished school and started working, or even for a spouse. So it could be for a fixed time, it could be for life, it could be, it depends on the circumstances of the case. If you have a child that is, for instance, handicapped and will not be able to fend for himself or herself, it's possible that the maintenance order could be for life with respect to that child. It could be for the joint lives of the parties, or if other order is made. Because, like we said, it's a maintenance order. It's an interlocutory order, such that, unlike most other judicial proceedings, when the court gives the judgment and you leave, that is the end. The case, the judgment is enforced, and that is it. But with respect to maintenance, you can always come back to court and ask that the order, and we'll be looking at that, be varied or discharged or what have you. So it could be, if it's a lump sum, of course, you pay it once and for all, and that is it, especially when it's for a spouse. If it's a periodic order, the periodic order that is given as a temporary order pending disposal of proceedings, of course, will terminate when the principal proceedings are had, and then you give a permanent order. That permanent order, like we keep emphasizing, is permanent in the sense that it was given at the end that the proceedings ended, but it does not stop the order being then limited for one reason or the other. For instance, when a spouse remarries, a wife remarries, you are not going to be paying maintenance on the wife of another person. The maintenance must stop. Okay, and then don't forget that the maintenance is given because it's a need assessment order. It's not just you get it as of right. A court must see that there is a need for it because we have regard to the means, earning capacity, all those things that are listed in Section 70 or the Matrimonial Causes Act, to determine whether this person actually needs to be maintained, to be assisted, to be helped by the divorcing spouse. So if your circumstances have changed, then that order may not continue. Then the court may also give any other order, apart from the maintenance order, that it is important. So the principles of maintenance under Section 3 of the MCA, which we have made veiled references to, are here now, that the order may be discharged upon the remarriage or any other just cause. You can distance, that is, the court stops the order. You don't have to pay the money again. It may be modified, the effect of the order, or suspended, or in wholly or in part. So you can modify the order. You might say it should be paid only, not monthly again, but maybe quarterly. You might suspend it and say, don't pay for this period. Maybe the person is not working or is sick or whatever, don't pay it in this period. It may be removed completely or in part. There is liberty to move around based on the changing circumstances of life. And the order that has been suspended, it could be revived. So thirdly, the order could be revived, discharged, it could be modified, it could be revived if it had been suspended before. It could be varied, that, okay, maybe you were paying 100,000 before, there is inflation now, begin to pay 200,000. But it could be reduced, okay? Then the circumstances, the order for decreasing or increasing the amount of maintenance can only be made if there has been a change in the circumstances of the parties, or if there's evidence that the initial order was made in error, maybe because he withheld some facts. Maybe the husband did not disclose his financial standing accurately. So there are some of the reasons why the court could increase or decrease the order. In conclusion, therefore, we can say that there are two types of maintenance under the MCA, the permanent and the temporary, and they can be given as lump sum or periodic order payment mode. They are interlocutory orders, though called permanent, because the court that gave the order has the power to vary it as the circumstances of the case may determine upon application before the court. The provisions of Section 3, as discussed above, regarding the ways that the order may be interfered with, may be given, apply to the ancillary reliefs under the Matrimonial Causes Act. These principles that we've just examined, don't forget, they apply to the Matrimonial Causes Act and to parties that are married under the Matrimonial Causes Act. Other parties, other marriage forms are regulated by their own legal system. If it is customary marriage, you have to look at the principles of customary law regarding whether the parties have any rights to maintenance from each other. Whether the parties are married under Islamic law, you have to look at the principles of Islamic law in this respect. However, note that even though we said this maintenance under the Matrimonial Causes Act They apply when there is a matrimonial clause in a statutory marriage and can be given for the benefit of a child of a spouse or a child of the marriage. There are other provisions regarding maintenance of children under the Child Rights Act, which we shall be looking at in subsequent presentation. Don't forget once again to subscribe to the channel and share the video.